Clausewitz once said that war is a continuation of politics by other means, and the Nuremberg trial was a rather infamous and dirty continuation of war by other means. This was a chance for the pinstriped lawyers of Washington and England and France and Moscow to show a little bit of valor themselves and to have a bit of a chance to go out and kill a few of the enemy while there was still any chance to do any killing. Towards the end of the trial, one of the American Army generals, all of whom deeply disapproved of the Nuremberg trials, said to the chief American prosecutor, Justice Robert H. Jackson, "It seems to me a rather costly exercise just to kill 20 people," which is basically what it boiled down to. And Jackson remembered that sentence because he referred to it later on in his memoirs, because deep down he knew that's what it was all about. The fate of these 20 men who were in the dock at Nuremberg was sealed from the beginning. Very few of them had a chance of getting off. The only ones who were going to get off were the ones who the Americans had deliberately picked, knowing they were innocent, and had put them in the dock with the others in order to cause dissension, to break open the ranks, which otherwise might have formed a dangerously silent body of defendants. 20 people, 22 people actually, were originally named on the indictment. They were picked in the most extraordinary, ramshackle, ad hoc way. They put on Martin Bormann, although they hadn't got him. They didn't know where he was, but they thought they ought to have Martin Bormann because all the newspapers had always been talking about him. So they put him on the charge sheet and included him, although he was long dead, buried under a pavement in West Berlin. And, of course, his skeleton was found years later. But he was put on trial in this macabre kind of exercise and tried in absentia with a lawyer representing him and no chance to speak up for himself, but he was put on trial. They needed to have an industrialist of some kind, so who was the best industrialist they could think of? Krupp, of course. So they took Krupp. Then there was a bit of a confusion. Which Krupp are we talking about? Well, it had to be Gustav, because he was head of the dynasty. So they put Gustav Krupp on the list of defendants in August 1945, along with the other defendants, and too late they recognized that Gustav Krupp was totally incapable of being put in the witness box. He was ill, he was senile, he was unable to speak, and yet they were going to put him in the dock. An enormous barrage of telephone conversations went back and forth between London and Berlin and Nuremberg and Washington, just over the Krupp business, about this appalling blunder of putting a man who was old and senile and totally unfit to be put on trial in the dock at Nuremberg. Somebody said, well, let's take his son then. Let's put Alfred Krupp in the dock. And then they had the bit of a problem that they couldn't find anything against Alfred because he wasn't actually on any of the boards at the time. And it would be an extraordinary case of kind of shuffling around the pack trying to find somebody with the right name and the right age to put into the dock, even though there was nothing against him. Then the French said, okay, let's take Bertha Krupp, the wife of Gustav, because she's fit. And Jackson says, I do draw your attention to the fact that we are expecting a large number of death sentences at the end of this case, and this might mean, therefore, putting Bertha Krupp on the gallows. And are the other members of the prosecution team willing to see a woman being hanged? Isn't that going to be rather bad for our image? This was the kind of thing that happened. And yet, although it may sound as though I've got a disrespectful view of Justice Jackson, in fact, he was your typical naive, childish, innocent, upright, honest, wide-open, blue-eyed American. He hadn't an ounce of malice in his soul. He didn't have any formal legal training. He started practicing law before the law courts of Pennsylvania without actually having qualifications to appear before the bar there. But he was so successful there that he very rapidly became a successful and very famous lawyer, and he became chief legal advisor to none other than Henry Morgenthau Jr. in the U.S. Treasury Department. And there he attracted the attention first of President Roosevelt and then of President Truman. And it was President Truman who gave to Jackson the job in April and May 1945 of investigating the possibility of putting the war criminals on trial. The war criminals gradually became whittled down. You notice that the Italian war criminals were never put on trial. They were just shot out of hand. And there's a story behind that too, because if you go through the historical records, you can see that this is what originally we British wanted to happen to all of the German leaders. Winston Churchill and Anthony Eden and the leading members of the British cabinet were all unanimous that there should be no trial, because trials often bring embarrassing details to the surface. And Churchill wanted no embarrassments. He wanted a quick, clean, surgical, executive act, as he called it, whereby all the German leaders would be rounded up and executed the next day. There's no question about this. This isn't one of those apocryphal stories that emerges at the end of a war, because in October 1944, Churchill was over here at Quebec meeting President Roosevelt, and typed on his headed notepaper is a 2-page document in which Churchill recommends this, so they should round up the 400 or 500 leading Nazis and then summarily execute them without trial. And he got President Roosevelt to initial this document, to approve it. And Churchill then sent it across to Moscow for Marshal Stalin's approval, and much to everyone's astonishment, Marshal Stalin said that he didn't approve. He said, I think that there should be trials, because otherwise the world will say afterwards that we were frightened of putting these people on trial. And he was quite right, of course. So it was Stalin, in fact, who insisted there should be a proper trial. None of the Americans wanted a trial. President Roosevelt said there shouldn't have been a trial. Cordell Hull, the Foreign Secretary, the Secretary of State, actually coined the phrase that he thought that all the Nazi leaders should be rounded up, held in a secure place, and that on the following day there should be a historic event at dawn, as he put it. Quite obvious what he meant. In April 1945, Truman gave the job to Jackson. He said, go to Europe and see if you can get agreement among the four major powers, Britain, the United States, France, and the Soviet Union, on a means of putting them on trial. And Jackson, who was an idealist, if he was anything at all, saw in this not only a way of bringing about a new body of international law, but also a way of advancing his own personal cause, because he had designs on the presidency. And he went into this with great enthusiasm. Now, when I wrote my account of this, which was published for 7 weeks in the German national newspaper Die Welt many, many years ago under the title of Die letzte Schlacht, The Last Battle, a lot of these people were still living, so I was able to interview them. Jackson, of course, was dead, but I interviewed a lot of the American lawyers. I interviewed a lot of the British lawyers, the British chief prosecutor, Sir Hartley Shawcross, now Lord Shawcross, still alive. I interviewed, of course, a lot of the German war criminals and witnesses who had been in the Nuremberg trials. I also got hold of their private diaries. I got hold of the private diary of Julius Streicher, who was one of the defendants, the diary of Keitel, the diary of Raeder. We now have the private papers of Rudolf Hess. We have a lot of the evidence dealing with how the trial came about and how it was prepared on both sides. It's a real battle. And you're, as a historian, able to look at both how one side fought the battle and how the other side defended against it. And you can see, in particular, the dirty tricks that were used. The dirty tricks began, in fact, even before the trial began, because President Truman gave to Jackson instructions to ensure that there was no way in which the Germans would manage successfully to defend themselves. And if you wonder why there was no trial against the Italians, it was because, in the case of the Italians, there had been an executive decision to round up the Italian leaders and turn them over through the OSS to the Italian partisans with instructions that they were all to be assassinated, which is then what happened. Mussolini, Clara Petacci, Farinacci, all the Italian leaders were rounded up and either severally or together, they were shot out of hand without any kind of trial. And that was what originally was going to happen to the German leaders. But for political reasons, they decided to use the German leaders as the basis for creating a new body of international law to make wars impossible in future. This was the grand design that Jackson had, that you could make it a criminal offense to wage a war of aggression, to have a conspiracy to wage war, to commit crimes against humanity, and so on. In London, the main prosecutors who were going to take part in these trials met in June and July 1945, and the result was the London Charter of August 8, 1945. And the London Charter not only defined the crimes that the Germans are going to be found guilty of having committed, which of course is a bit of an irony because we're talking about 8th of August 1945, and all the crimes that they were going to be accused of having committed were committed before the law was set up defining it as a crime. There's a Latin legal definition which says you can't do this. Nulla pone sine lege. No punishment without law. But this is precisely the Latin definition which was going to be breached by the London Charter. A body of law was specifically created with the intention of getting those 22 people. You rig a trial, you rig a courtroom, you rig the lawyers, and in the case of Nuremberg, you actually draft the laws. The Russian prosecutor who drafted the laws in London then went to Nuremberg and turned up there as the judge who was going to try the German defendants on the basis of the laws that he himself had helped to draft and formulate. Not only were the laws drafted in London, but also the rules of the game, the rules of this particular piece of German dating, whereby every possible defense was ruled out a priori. For example, you would imagine that Field Marshal Keitel, who was put on the dock, the chief of the German High Command, would be able to say, but I was only doing what the Führer ordered me to do. The defense of superior orders was specifically ruled out by the London Charter. Those clever lawyers thought the Germans are going to plead superior orders, so let's say, we won't allow you. That one's out. Try another one. Okay, so the Germans could have said, okay, you're going to accuse us of bombing civilian populations. But you did the same, only 10 times worse than we did. This defense is known to lawyers as tu quoque. You did it too. The tu quoque defense was also explicitly ruled out by the London Charter of August 8, 1945. So bit by bit, the defense possibilities were whittled away, even before they drafted the list of defendants. And in order to make it absolutely specific that the German defendants had no chance, the British and the Americans had actually changed their own rules of war 1 year previously. Let me explain why. Under the Geneva Convention for the Treatment of Prisoners, it is laid down that a captured prisoner can be accused of war crimes and put on trial only by a properly constituted court-martial, which is one reason, of course, why the Nuremberg trial was called the International Military Tribunal. There was nothing military about it, but they needed the word military in it, just in case anybody remembered the Geneva Convention for the Protection of Prisoners of War. The Americans didn't pay any attention to the Geneva Convention for Protection of Prisoners of War. After the war was over, they didn't need it anymore, so they quite simply took these prisoners prisoners and called them discharged enemy personnel. And you could do what you wanted with them. This was totally unjust and illegal. Now, you can only put a captured prisoner on trial by a court-martial. But that's not the only provision of the Geneva Convention. There's a second very important provision which says that if you capture a general and you're going to put him on trial, then he can only be put on trial by a court-martial of your own generals or officers of a rank superior to general. The court-martial has to be from people of equal or superior rank. You might say that the Russians weren't entitled to this kind of protection because the Russians had deliberately refused to sign the Geneva Convention. People overlooked that fact. So they did what they wanted with the German prisoners, and the Germans did what they wanted with the Russian prisoners. But after the war, the Geneva Convention was considered to be binding on the Germans, and the Geneva Convention, the people who drafted it, are very wise because they also laid down in the Geneva Convention that no one party to the Geneva Convention could unilaterally abrogate it. After the war was over, the Americans and the British and the French and the Russians couldn't say, very well, we won, tear up the convention, we're quitting the convention, we're going to play the game by a different rule now. You can't do that. The Geneva Convention continues to carry on in force for a specific number of years after the end of hostilities. Didn't do any good because the victorious powers in 1945 decided to ignore the Geneva Convention, take all these prisoners that they wanted, put them first of all in Mondor prison camp, then take them to Nuremberg and put them in the dock. A totally illegal act. The mere action of turning the prisoners from the British zone taken prisoner by the British, for example, General Keitel, General Jodl, Admiral Dönitz, these prisoners who were taken prisoner by the British in Flensburg in the British zone of Germany, we turned them over to the American zone. That is a criminal offence under the Geneva Convention. You are not allowed to hand over prisoners of war to a third power. All this is rather a waste of breath on my part. We were the victors. We could do what we wanted. And we did. We drafted the laws. We drafted the rules of the court. We made it impossible for the Germans to defend themselves properly because we ruled out specifically in advance all the things that they could have used. If the Germans had managed by some miracle to enforce a proper court-martial, then the Germans were entitled to one specific defense, which was this. A German general being tried by a court-martial was entitled to be tried by the rules of war as defined by the victorious power. In other words, the British rules of war would be binding for a court-martial against the German general. But until April 1944, the printed British Manual of the Rules of War contained a clause which said that any British soldier or any soldier required to commit an illegal act by a superior officer shall not be accused of having committed a war crime if it was an order given to him by a superior officer, which of course is a defence for the Germans because they could have pointed to the British rules of war and said, you must try me by your law book, and your rule book says that superior orders is a defence. But you remember I said that this was only the British manual until April 1944. After April 1944, we deliberately, the British, changed the manual to exclude that paragraph so that the Germans wouldn't be able to point to it when the war was over and demand to be tried and exonerated by virtue of that paragraph. We were thinking, you see, way ahead. So we drew up a list of defendants to put on trial at Nuremberg. Why Nuremberg? Well, really, it was an American trial. The Americans were the dynamo behind the trial. They provided the $4 million that the trial finally cost. They held most of the prisoners. They certainly had most of the evidence and the documents in their hands, and they insisted that the trial should be held in the American zone. And the only city that had a courthouse and a prison that was intact enough to restore in time for the trial was Nuremberg. So Nuremberg became the site of the trial. The trial began in November 1945. The British said, we hope it'll last only 2 weeks. The British were still thinking rather in terms of summary justice in the form of give your name, rank and number, step over there against a wall and shoot them. But in fact, the trial lasted nearly a year. It was an extraordinary trial, and it was fought with great bitterness, and it's not a credit, unfortunately, to the British or the Americans, and in some ways it's not a credit to the Germans either. If you read the diaries of the prisoners, the German prisoners, you see how we maltreated them and how we tortured them. You see how we blackmailed them. You see how we used pressure and torture to persuade them to give false evidence. You see the slimy methods we used to play off one prisoner against another. Justice Jackson introduced a prison psychiatrist called Dr. Gilbert, whose job it was to provide succor and solace for the prisoners, of course, who were in a position of great mental turmoil. And Jackson writes in his diary how useful it is, because every day Gilbert came to him with all the reports on the conversations he'd had with the prisoners, where the prisoners had been discussing their cases with him, as between patient and doctor, and explaining the tactics they intended to use the next day. And Jackson says how useful these psychiatric reports were for us in preparing the next day's prosecution tactics. Hidden microphones in the cells so that the prisoners' conversations with their defense counsel could be overheard prepared by the prosecution to provide the prosecution with advanced tactics for the next day's hearings. The documentation was available really only to the prosecution. Of course, the Allies had captured tens of thousands of tons of documents, but the Defense Counsel were only given access to the documents that were introduced into the case by the prosecution. Now, there's a very good book on World War II written by an American historian called William Shirer, The Rise and Fall of the Third Reich. A very early book. It's a very good book, though, although it's written entirely on the basis of the Nuremberg documents. The problem with the Nuremberg documents is that it is a body of documents collected for the purpose of prosecuting 20 people. So it contains all the black stuff, all the crimes, all the dirt, all the nasty details of the crimes committed by the Nazis. Hermann Goering, the chief of the German Air Force, put on trial, of course finally hanged. He knew he was going to be hanged. He put up a very brave defense. We British had captured the entire shorthand records of every conference he had ever held. I saw them all. I read them all back in the 1960s and 1970s. 80 volumes of the things. 800 pages in each volume. So you can imagine that 60 or 70,000 pages of documents. And I spent probably 6 months reading through them when I wrote my biography of Hermann Goering. Now, the Americans were allowed to go through these 60 or 70 volumes, and they picked out a page here or a page there where Hermann Goering or Fritz Sauckel, the manpower commissioner, had lost his temper and said, I'm going to have that man hanged, or a cruel reference to slave labor or something. These individual passages were taken out and typed up by the Americans and duplicated and put into the document center at the Nuremberg courthouse. And the defense lawyers had to go to that body of documents and use those selected extracts to try and build their defense case. Instead of being able to go to the 70 volumes of the original transcripts and use them, looking for things that would exonerate their client, they couldn't do that. Although, for example, we see Fritz Sauckel in these same conferences saying, I do insist that if we're going to use this labor from France and Russia, I do insist that these people should be properly fed and given proper clothing and proper accommodation. Otherwise, we're not going to be able to get any work out of them. A humane attitude that would have probably spared him from the gallows. But it didn't, because these documents were not available to the defense. I spoke to all the defense counsel who were still alive many years ago, Fritz Bergold and Kubuschok and Jahrreis and Servatius and all the leading German lawyers who fought in the Nuremberg action, and they were all very bitter about the difference between the American approach to legal process and the German approach. In the German court system, the two sides, the defense and the prosecution, have a common duty to arrive at the truth. So if the prosecution in a German court action finds a document that is of use to the defense, it is duty and honor bound, and indeed bound as an officer of the court, to make that document available to the defense without being asked, because it is their joint duty to arrive at the truth. In Nuremberg, it was very much more the American system, an adversarial system, where each side tried to trick the other. And if the prosecution had a document that they knew would aid the defense, they burned all the copies of that document, which makes it quite difficult to be a historian now, because you can find the gaps in the records where the Americans destroyed volumes of documents that are no longer there. Not only that, when the defense started asking for witnesses, for example, they asked for Karl Wolff, who was the chief of staff to Heinrich Himmler. In the case of Ernst Kaltenbrunner, Himmler had committed suicide, so Kaltenbrunner was put on trial, subsequently hanged. The defense counsel for Ernst Kaltenbrunner asked for Karl Wolff to be available as a witness, but the Americans said they didn't know where he was. The Americans knew very well where he was, because he was in an American prison camp. When eventually the defense lawyer for Kaltenbrunner identified the prison camp where Karl Wolff was being held, the Americans took Wolff out of that camp and put him into a lunatic asylum, claiming that he was now mentally deranged. And it took Karl Wolff until May 1947 to get out of that lunatic asylum, when Field Marshal Milch managed to have him summoned as a witness, and Wolff was produced in the Field Marshal Milch case. And at the end of his testimony in that case, Karl Wolff stood up as he was being led out of the witness box, and he said, "One moment, I would like to ask the judges on the bench if they have been satisfied with my evidence, and if they consider that I am a person of sane mind." And the judges said, "Of course, we're very impressed by the evidence you gave, General." Whereupon Karl Wolff said, "Well, because the American officers are about to take me back to a lunatic asylum, where they've been holding me incommunicado so that I couldn't give evidence in cases like this." And the judges then ruled that he should be set free on that day. With dozens of witnesses, the Americans pretended they didn't know where the defense witness was. If it was a prosecution witness, then the Americans were prepared to fly him from any corner of Europe. They would put him up in the Grand Hotel at Nuremberg, the luxury hotel which the Americans had restored. They would provide him with food and accommodation and a driver and all the other pleasantries of life if he would give evidence as the Americans required. But woe betide those who said they wouldn't give the evidence the Americans wanted. On November the 5th, 1945, a strange American officer, Major Ernest Emery, turned up in the cell of Field Marshal Milch. England had said to Field Marshal Milch, "You're going to come to Nuremberg to give evidence against Goering, your chief, aren't you?" And Milch said, "No, he's not exactly my best friend, but I believe in comradeship dictatorship, and I'm not going to do the Allies a favour in any court. So England has said, Field Marshal Milch, I do advise you that if you don't give evidence against Reich Marshal Goering, as we required at Nuremberg, then we will put you on trial for war crimes too, and you too will be hanged. Field Marshal Milch said, I have a clear conscience. You can't prove or substantiate anything against me. England has said, makes no difference. We're capable of forging a case against any German that we want to, for our own purposes. Field Marshal Milch was brought to Nuremberg. He was put in the dock, and he gave evidence to everyone's astonishment on behalf of Hermann Goering, his former deadliest rival and foe in the German Air Ministry. The next day, he was taken to Dachau concentration camp, which was now being run by the Americans under new management. In April 1945, when the Americans liberated the camp, they took 560 of the German soldiers they found there and lined them against the wall and machine-gunned them to death. There's photographs of it. It's the most appalling crime that the Americans committed at that time. The Americans now ran Dachau concentration camp. It was filled with German judges and lawyers and generals and people whom the Americans disapproved of. And in the Strafbunker, which was a little room where the SS had put prisoners who they wanted to penalize, they now threw Field Marshal Milch along with 12 other field marshals in this tiny room where there wasn't even room to lie down. They kept him there for 2 months as a punishment for having given evidence in Hermann Goering's behalf at the Nuremberg trials. And not just Hermann Goering. There's a whole string of evidence of cases where the Americans intimidated witnesses to get the evidence they wanted. In the case of Grand Admiral Dönitz, for example, now I know from the private files of Justice Jackson, which I saw originally in Chicago, but they're now in the Library of Congress in Washington, that the American Navy Department in August 1945 had, in conformity with the British Admiralty, reported to the prosecution teams at Nuremberg that after reviewing the entire captured German Navy records, they'd come to the conclusion that Grand Admiral Dönitz, the chief of the German Navy, had fought an honourable battle, he had committed no crimes, and that there was no case for prosecuting him. His name still ended up on the list of the people indicted at Nuremberg. He was put in the dock, and he was subsequently sentenced to 10 years in Spandau prison. To try and get Dönitz, the Americans did this. There had been one particular scandalous episode during the war in about 1942 or 1943 involving a German submarine which had sunk a Greek merchant ship called the Peleus. And after this Greek merchant ship had been sunk, this German U-boat, commanded by Captain Lieutenant Eck, had then machine-gunned all the survivors, killing them. There's no doubt about this. It can't be concealed. Eck and his senior crew officers were held in British captivity with hidden microphones, and I've got the actual transcripts of where they're discussing this particular crime. Eck and his two senior officers were both stood before a British firing squad in Hamburg after the war, after a court-martial for the crime they'd committed. This crime is not important in this particular connection, nor is their trial. What is important is that this was the only crime that the Americans believed they could hang round the neck of Grand Admiral Dönitz, and yet they couldn't find the important link. So they went to his chief of staff, a Rear Admiral Eberhard Gott, who described this business to me in a letter. He said he was in American captivity, and he was interrogated by an officer of obviously Czech origin, who said to him, Admiral Gott, we want you to testify that your commanding officer, Grand Admiral Dönitz, issued an order on the basis of which Captain Lieutenant Eck machine-gunned the crew of the Peleus. And when Gott said that this isn't true, the Czech officer said to him, you do realize that if you don't testify to that effect in the Nuremberg trials, as we request, or swear an affidavit to that effect, then we intend to hang you along with Admiral Dönitz. Exactly the same threat. Gott, fortunately, was a German naval officer with the correct tradition and upbringing, and he said that he would prefer to die if it was necessary to protect the honor of the German Navy and his commanding officer. He refused to swear the affidavit, and they had to abandon that particular line of action against Grand Admiral Dönitz. And not just him, but on the diplomatic front too. The Americans used violence and terror and intimidation. When they wanted to try and destroy the evidence which was embarrassing the Russians so much, you remember the Russians in August 1939 had signed a pact with Hitler. Fortunately for the Russians, there was no copy of this pact in existence. There's only a microfilm of it. So nobody knew where the original document was, and the Russians swore on a stack of Bibles, or Talmuds, or whichever was their particular version. They swore on a stack of these books that the pact had never been signed, and that Stalin, good Lord, no, he didn't think very much about Adolf Hitler at all. Ribbentrop and Molotov signed the document together, good Lord, no. What a lie, what a legend. Another of those gas chamber stories. But the document did exist, of course. It was signed. It must be in Stalin's archives. Eventually, an unknown anonymous American officer smuggled a copy of the Hitler-Stalin pact taken off the microfilm to Alfred Seidel, Rudolf Hess's lawyer. And Rudolf Hess's lawyer, Alfred Seidel, made a big song and dance about this Nazi-Soviet pact because, of course, if it was true, then it showed that the Russians, who were sitting on the judge's bench, casting down their sentences on the Germans who were sitting in the dock, were guilty of precisely the same crimes of aggressive war against Poland. Here they are, signing a pact in August 1939, carving up Poland in anticipation of Poland's defeat. And it was very embarrassing for the Russians. And the Russians could only huff and puff and bluster and say that the document was a forgery and had never existed and never been signed. And at this moment up stood a German diplomat, a lawyer called Dr. Friedrich Gauss. He was Ribbentrop's chief legal advisor in the German Foreign Ministry. And he said, not only is this document genuine, I was there in Moscow when it was signed, and I was the one who drafted it. And I was a witness to the signature. My signature is on the document as a co-signatory and a witness. Very embarrassing for the Russians, hugely embarrassing for the Americans. Gauss said this verbally when Seidel approached him and said, are you prepared to swear an affidavit to this effect, which I will need to introduce the matter in court? Mysteriously, Gauss had been afflicted by a sudden loss of memory. He was no longer quite so certain. What had happened between those two events? The answer is he had been got at by an American lawyer called Dr. Robert M.W. Kempner. He wasn't an American at all, of course. He was born in Germany. Until 1933, he had been a Jewish lawyer working in the German Ministry of the Interior. In 1933, that came under new management, namely under the Prussian Ministry of the Interior. The new Prussian Ministry of the Interior was Hermann Goering. And Hermann Goering said, I don't like the look of your face, Mr. Kempner. Kempner had to go, and Kempner, who was a wise person, decided the best place to go to would be the United States. And he stayed in the United States until he returned to Germany in 1945 wearing the proud uniform of a colonel of the U.S. Army. Now, in Jackson's favor, it has to be said, and it's in his memoranda, it's in his documents, that when he was setting up his prosecution team, he laid down one important principle. He says, I don't want no Jews on my staff. If we have any Jews on my staff, they will change the whole nature of the case. And not only that, everybody will then say in no time at all, it has turned into a Jewish vendetta against the convicted Nazi criminals. And I don't want posterity to be able to say that. But he said in his memoirs and in his diary subsequently, unfortunately, I was obliged to accept one, Robert Kempner, who became the chief of my rebuttal division. And there's a memorandum in the Jackson papers from his son, Bill Jackson, who says, you do realize that Kempner is totally incompetent and useless. The reason I mention Kempner is because Kempner, it turned out, approached Friedrich Gauss, this lawyer on Ribbentrop's staff, the man who was about to swear the affidavit. And Gauss subsequently swore an affidavit in a later trial in which he revealed that Kempner had approached him and warned that if he swore the affidavit on having witnessed the Moscow signature, then the Americans would see to it that Gauss would be shipped immediately out of Germany and turned over to the Poles or to the Russians for suitable special treatment. This was the way the Americans got the evidence they wanted in that trial. They also used the traditional methods of torture, starvation, extreme cold. They knocked all the windows out of the cells of the German prisoners, even in the case of somebody like Field Marshal Keitel, who was nearly 70, through that bitter winter of 1945-1946, no heating, very little food, with the deliberate intention of depriving them of moral sustenance so they couldn't fight back. The prisoners who had wives and children were told that their wives and children had vanished. They wrote letters, but they got no replies. The letters were taken by the American guards and auctioned. They were sold. They turned up on the American auction market now if you go there. You find letters that Hermann Goering wrote to his wife. Never reached Emmy. Emmy and Edda Goering at that time were locked up in a prison in Straubing by the Americans. A little 7-year-old girl locked up by the Americans. And gradually the defendants were then told the fate of their wives and children that they were being held. Also in cold and frozen, starving conditions in prisons by the Americans. Every possible means was used to degrade and humiliate and demoralize the prisoners so that they couldn't fight back. In subsequent trials it was far worse. The American army conducted a trial in Dachau concentration camp against the members of the SS unit whom they accused of responsibility for the notorious Malmedy massacre. A mass trial with hundreds of defendants. The result was no fewer than 30 or 40 of the SS officers were actually sentenced to death. But before they were hanged, an American commission of inquiry, fortunately, hurried over to the European theatre of operations and carried out an urgent investigation into rumours that they had heard. And if you want to know the result of this commission of inquiry, it's called the Simpson Commission of Inquiry, named after the U.S. Supreme Court Judge Simpson, who carried out this investigation. You can do two things. You can read a book called Manstein, His Trials and Campaigns, by the British barrister R.H. Paget, who defended Manstein before a British War Crimes Court. Or you can go to the National Archives, which I then did subsequently back in 1960, my first contact with the National Archives in Washington, and ask for all the records of the Simpson Commission of Inquiry. And then you will see the ugly truth, that of the witnesses investigated by this U.S. Court of Inquiry into the trial procedures of the Americans in the Malmedy case, of the SS officers and men who were questioned by the American interrogators, no fewer than 146 had had their testicles permanently smashed by being kicked by the Americans in the process of the investigation. And that wasn't the only torture inflicted on them. Seeing this evidence of the torture, the American Court of Inquiry immediately reviewed all the sentences, and almost all the sentences were commuted to terms of imprisonment. Only 2 executions were carried out. All the other cases were abandoned. The other thing is that when the trials began, the original investigations in the summer of 1945, 1945, it looked for a long time as though the trials were going to be conducted not by the American legal teams, but by the American Office of Special Services, the American Secret Service, while General Donovan was going to be the person who was in charge of the actual trials. And it took a lot of maneuvering on Jackson's part to get Donovan sent back to the United States. But for a long time, the OSS methods prevailed. Interrogations were carried out of German prisoners in the Nuremberg trials, in which the prisoners, rather like in the West Bank of Jordan now, in the occupied territories of Israel, the prisoners were sat with hoods over their heads and didn't know what was going on. They were interrogated in total darkness. They were then told at the end of the interrogation that in fact it was a court procedure, at the end of which they were then apparently sentenced to death. And they were then taken out and stood against the wall. And at the last moment, after they've heard the rifles clicking, they're told that they have been pardoned and that they're going to be brought back for another interrogation. These were the methods that the American interrogators used. You can actually see in one interrogation of Hermann Goering in August 1945, after the interrogation had just begun by an American lawyer called Colonel John Armin, Goering suddenly interrupts himself and he says, wait a minute, before I answer your question, can I just ask this? Is this just an interrogation or is this the actual court procedure? Has the court hearing actually begun? Because he's been led to believe that this is the court hearing that's begun. These were the methods that the Americans used. I'm not saying that we British used the same methods. We operated in a rather different way. We operated in a rather underhand way, the British. When I interviewed one of the American lawyers, Ralph Albrecht, who was in the Jackson prosecution team down in New York, Albrecht said to me, Irving, you know, you English guys, you're pretty strange types. I remember down in Nuremberg there was this English colonel called Fillmore. And Colonel Fillmore came up to me and he said, Dr. Albrecht, you Americans are responsible. No, he said, you Americans are responsible for prosecuting Hjalmar Schacht, aren't you? Now, Hjalmar Schacht was the head of the Reichsbank. He was the man, the economic wizard who made German rearmament possible. Very important economic wizard, financial expert. He was put on trial at Nuremberg. And Fillmore went to Albrecht and said, we have had representations made to us by our team that we'd be rather grateful if you went kind of a bit easy on Schacht. We would hate anything to happen to him. Well, Schacht is, along with the defendants, in the dock at Nuremberg. And Albrecht says to me, Mr. Irving, I told Fillmore, your guy, our Chief Prosecutor Jackson, considers that Schacht is the worst criminal of the lot. He's the one who made the financing possible in the first place. Without his finance, German rearmament wouldn't have been possible, and we wouldn't all be here today. So Jackson thinks that if anybody's got to swing, then it's going to be Schacht, because he's here representing German finance and German industry. But on the other hand, if you can tell us why the British seem to think that Schacht should be treated more leniently, then I can put this case to Jackson and see what he says. So Fillmore said, well, it's rather embarrassing, but the position actually is that the British think that it would be very grateful if you did soft pedal the case against Hjalmar Schacht, because certain representations have been made to us by Sir Montague Norman, the governor of the Bank of England, who's an old friend of Schacht's, and we would very much deprecate anything untoward happening to Mr. Schacht. So what happened? Let's leap forward to Judgment Day. Hjalmar Schacht is acquitted. How did it happen? We now know from reading the private diary of Judge Biddle, whose private papers and diaries are down in Syracuse University in New York State, private papers of Justice Jackson. We know that what happened inside the judges' committee when they were deciding on the sentences. There was no jury, just the four judges. Judge Biddle wanted Schacht executed. The Americans wanted Schacht executed. The Russians wanted him executed. The French wanted him executed. Only the British judge, Sir Norman Burkitt, said, I think that we should acquit Schacht. And he held out. So it had to be unanimous. And Burkitt held out for an acquittal, and finally, as a part of some kind of horse trading behind the scenes, Schacht was acquitted. Unremarkable, you might think, except for one extraordinary factor which linked all four people. Hjalmar Schacht, Fillmore, British lawyer, Norman Burkitt, the judge, Sir Montague Norman, the governor of the Bank of England. Can you guess what the linking factor between all four people was? High-grade Freemasons, all four. It was the Freemasonry on that occasion that got Schacht off the hook in Nuremberg, but not off the hook, because no sooner had he stepped out of the courtroom doors than he walked right into the arms of the waiting German police, who took him into custody, arrested him, put him on trial, and he was sentenced to 8 years' prison by the Germans for war crimes. That's what happened. Let's move ahead then to the final day. What happened to the defendants? Albert Speer, who had given Justice Jackson all the help he possibly could, because Albert Speer considered himself to be somewhat superior to the other defendants. In Jackson's papers now down in the Library of Congress, there's a whole sheaf of penciled letters written by Albert Speer to him during the months before the trial and the trial itself, in which Speer offers little pieces of advice and encouragement about how to get this defendant and how to get at Hermann Goering and how to undermine the defense of his other rivals. Typical Albert Speer. Jackson wrote in his diary, I think that Albert Speer should be acquitted. Much to his astonishment, Albert Speer got 20 years, and I don't begrudge him one of them. I must say that. I think Albert Speer deserved the lot. Some of you know this, but I'll say it again. Those of you who had the Albert Speer memoirs, very famous book, a huge international worldwide bestseller. It wasn't written by Albert Speer. Speer read out his memoirs to me for a whole afternoon when he came out of Spandau prison. Totally different from the book finally published. It was written by 3 other people for him. That's unimportant. What is amusing is the publishing contract that Speer signed with the Ullstein publishing house, my publishing house, in Berlin, after he was emerged from Spandau prison. He signed a publishing contract, and I'd heard rumors about it, but it was finally a famous German film director, a woman, who showed me a photocopy of the Albert Speer publishing contract, which has the unusual clause, which I can guarantee is not in any contract I've ever signed, which says, I, Albert Speer, herewith agree that 1/4 of all the proceeds and earnings of these memoirs shall be paid direct to the State of Israel. And therefore we understand why the book has become an international, worldwide bestseller. What about the others? Grand Admiral Dönitz, whom we, the British, had already found totally not guilty on the basis of the records of the German naval staff, was sentenced to 10 years in prison. His predecessor, Admiral Raeder, got 20 years but was subsequently let out early because of bad health. Nobody let out poor old Rudolf Hess because of bad health. He was held, of course, for 47 years in prison after being sentenced to life imprisonment. 47 years in prison from the day that he arrived in Scotland in 1941 right through to his death in August 1987. Of those 47 years, 20 years were in solitary confinement. So you're talking about crimes against humanity committed by the Germans, and in order to make it good, you commit a crime against humanity against the one man who did everything he could to restore the peace. And then there was Hermann Göring. When I wrote my biography of Hermann Göring, I managed to obtain from a secret source in Berlin the letters that he had written, because, of course, Hermann Göring was going to be hanged. They were all sentenced to be hanged. All the ones sentenced to death were sentenced to be hanged. There was going to be no firing squad. This was a final act of infamy, I think, on our part. Even the soldiers and the sailors were going to be hanged like common criminals. And quite rightly, General Jodl and Field Marshal Keitel and the others, they didn't appeal the sentence of death, but they did appeal to be shot instead of being hanged. But Hermann Göring went one better, because he had done a deal with an American officer, a Texan who was a huntsman like himself, and he had done a deal with this officer whereby the officer, in return for certain private goodies like a very nice Swiss Mont Blanc fountain pen, in return for these things which were in Hermann Göring's private property held in custody by the commandant of the Nuremberg prison, Hermann Göring said to this Texan, who had become a close friend of his, if you get me a certain item out of my private property which is in the commandant's safe, then I'll write over to you all the most valuable items in that safe and you can keep them. We know this because the Texan died about 10 years ago and these items were found in his family possession. I can only reconstruct what then happened. I think that the Texan said to Hermann Göring, okay, well, I'll get them out, but there's going to be a hell of a stink, because if I give you what you're after, which is, of course, the cyanide capsule, if I give you that, then there's going to be one hell of an investigation, and they're going to narrow it down, and it's probably going to end up with me. And Göring said, I'll write a letter which gets you off the hook. And the American, whose name was Jack Wheelis, quite obviously said, okay, then write that letter now, and give me the letter now, and I'll hang on to that letter, and after your suicide, I'll make sure the letter is found with you. Very clever. And Hermann Göring wrote not just one letter, but he wrote 4 letters, and they're all dated October the 11th, which is 5 days before the actual execution date. Now, you've got to say to yourself that if Hermann Göring had written a letter 5 days before the execution date and kept it lying around his cell, then he would have run a very severe risk indeed that that letter must have been found during a snap search of all the cells 2 or 3 days before the executions and read, and in that letter he says, I've got the cyanide capsule, it's been hidden about my person all this time. He would have run a severe risk of the whole plan being very painfully squelched. So there's no way that those 4 letters were left lying around his cell for those 4 days. He obviously gave them to somebody to look after, and that was probably Jack Wheelis. I'll read out to you just the last of the 4 letters because I got them. The Allied Control Commission that found them clutched in his dead hand ordered that these letters were never ever to be published. But I managed to find them in a safe in Berlin, and I published them for the first time. Hermann Göring writes, I find it tasteless in the extreme to stage our deaths as a show for sensation-hungry reporters, photographers, and the curious. This grand finale is typical of the abysmal depths plumbed by court and prosecution alike. Pure theatre from start to finish. All rotten comedy. I understand perfectly well that our enemies want to get rid of us, whether out of fear or hatred. But it would serve their reputation better to do the deed in a soldierly manner. In his other letters, he once again said, if they'd given me the firing squad, I wouldn't have committed suicide. But as it is, I'm not going to play along with their little game. I myself, he says, shall be dying without all this sensation and publicity. Let me stress once more that I feel not the slightest moral or other obligation to submit to a death sentence or execution by my enemies and those of Germany. I proceed to the hereafter with joy and regard death as a release. I shall hope for my God's mercy. I deeply regret that I can't help my comrades, particularly Field Marshal Keitel and Colonel General Jodl, to escape this this public death spectacle as well. The entire effort to stop us from doing harm to ourselves was never motivated by concern for our welfare, but purely to make sure that all would be ready for the big sensation. But ohne mich, count me out. Yours sincerely, Hermann Göring. And he swallowed the capsule. They were executed on October the 16th, 1945, not without a certain macabre piece of foreplay, because the hanging commission, a commission of 4 Allied generals, a Frenchman, British, American and Russian, had attended the final judgment day in court and demanded to be allowed to sit in the front row. And Justice Jackson said that would be tasteless and tactless in the extreme, because purely theoretically it was possible that there would be no death sentences. And having the hanging commission there in evidence in the front row would imply that the whole thing was an abgekartetes Spiel, that the deck was stacked against the defendants from the start. So he refused to allow them to come in, but they slunk in and sat up on the balcony on the judgment day when sentence was handed down, these 4 generals. And on the day of the executions, they got their revenge on Jackson, because when he sent his representative to attend the executions in the gymnasium at the Nuremberg prison, they slammed the door in his face, and they wouldn't let him attend. This nasty little piece of tit for tat on the final day of this particular story. The Americans are a tasteless people. An American officer at Nuremberg actually printed a first day cover. Stamp collectors among you will know what a first day cover is. Printed a first day cover for the Nuremberg execution day, on which were listed the names of all those who were executed, and special stamps stuck on the envelope and date marked and franked with the execution day, October the 16th, 1945. The hangings were carried out in a very clumsy manner by an American Army sergeant, who was so clumsy that a year later, when he himself was experimenting with a noose, slipped and fell and hanged himself. The hangings took 2 hours to perform. The account that is in the Jackson papers, written by an American Army officer who wrote down every word that was spoken by each of the defendants as they were hanged, shows that all of them died bravely. This particular officer had waited for the slightest sign of hesitation on the part of these Germans who were being hanged, and not one of them did. I would quote only the words, in fact, of General Jodl, who was the most outstanding of the German officers who was hanged that day. Jackson thought that Jodl shouldn't have been hanged. In fact, there was a piece of horse trading between the Russians and the British, which led to Jodl's hanging. The Russians wanted to have Rudolf Hess hanged. The British thought that would be unjust, but they agreed to let the Russians have Jodl instead. So Jodl was hanged. He knew he was going to be hanged, and on that day he wrote a final letter to his wife, who still lives in Nuremberg today, to Louisa, saying that they would be together in mind and spirit as the bells chimed for the last time that evening of the St. Lawrence Church in Nuremberg. They would both hear the bells chiming. Then he wrote these words: "When my friends gather around you tomorrow, on the morrow of the execution, that will be the funeral parade. My coffin is on a gun carriage, and the parade has begun, and all the German army is marching alongside. Out in front, the living soldiers, and the dead soldiers bringing up the rear." Thus died General Jodl and the other 12 who were hanged at Nuremberg. It was a brave attempt by Justice Jackson to create a new body of international law to make war crimes impossible, but in the intervening 45 years, of course, we have seen that it was a failure. The Israelis, the British, the French in Suez, the Americans in the Gulf, the Americans in Panama, the Americans in their repeated little wars since Nuremberg have shown again and again that no matter what the law says, you can always find some way of getting round it or just bulldozing clean through it. So these Germans died in vain. But I think that the whole world is now universally agreed, certainly lawyers are agreed, and soldiers and officers are agreed, that the trials of Nuremberg were as much a political show trial as the infamous trials that were conducted by Stalin in the years before the war in Moscow. Thank you very much.